the attorney-client privilege. We need to point out this issue. The attorney-client privilege, the protection of this privilege extends to the communication about past acts. This is important. Meaning is if the client comes to the attorney's office and tells the attorney whatever he already did, and then this communication is protected. If the client would say, has committed a crime, has committed a murder, has committed a robbery, this communication is protected because this is something the client already did. So this is above the communication. This is above the communication of the past acts. The privilege does not cover what a client intends to do. If the client would tell the attorney, we know there is a witness and who is going to testify against me, so what I want to do is I'm going to go out, I'm going to get rid of this witness so that he would not testify against me. If that is a situation, this privilege would not cover this kind of what a client intends to do. In this kind of situation, if the client tells the attorney he intends to harm someone, the attorney actually can disclose this information to the police because this is not above a communication of above past acts. This is something the client may do in the future. So this communication above this possible future act would not be covered by this privilege. Another issue we need to discuss is in this attorney-client privilege, we have this fraud and crime exception. So in the chapter, we have this case that is Clark versus the United States. In this case, the defendant committed, the client committed a murder, and then he actually called his attorney, and then his attorney asked him what he did with the murder weapon, and then the client said, I still have the murder weapon, and then the attorney said, get rid of the weapon. And then, of course, we know this conversation was overheard by this operator of the telephone company, and then the issue was whether this operator could come to court to disclose the contents of this communication between the attorney and the client. The defendant argued because this was a client and attorney communication, so the operator could not testify to disclose this communication. But the ruling of the court in the case was the operator could testify about this communication because this communication was not protected by the attorney-client privilege. Why this communication was not protected? Because in this communication, the attorney was advising the client to commit a crime. We already discussed, according to the law of all the states, destruction of criminal evidence is a crime. So the attorney cannot advise his client to commit a crime. If the attorney would advise his client to commit a crime, and then this attorney-client privilege would not apply. That is what we call the fraud and the crime exception. Fraud, the same thing. If the attorney would tell the client, why don't you go there and when you testify in court, and then just tell the court, a false story. Just come up with a fraudulent statement and then tell that to court, and then that is a fraud. And then if the attorney would advise the client to do that, this attorney-client privilege also would not apply, because according to this fraud and crime exception, that kind of communication would not be covered by this attorney-client privilege. So we understand this. If the lawyer would advise a client to commit a crime, and then this communication would not be protected by the privilege. On this issue, I think it is very important for us to point out if a client would go to attorney, and if we ask why this client would go to attorney, we would all say, oh, this client goes to the attorney because he wants to have this lawyer's legal advice. But we understand what the client should get from the attorney is the legal advice. Meaning is that advice has to be legal. The client cannot go to attorney to discuss how to commit a crime, and also the attorney cannot advise a client how to commit a crime, because if the attorney would do that, whatever the attorney is providing is not legal advice anymore. That is illegal. So if that is the case, very understandably why we say under this fraud and crime exception, the communication would not be protected by this privilege.